Chapter 3. Issue of shares. Question 6. Justify the following statements. 4 marks each. 1. Company has to fulfill certain provisions while making right issue. Answer. 1. Whenever a company proposes to increase its subscribed capital by issuing further shares, it can offer those shares to the existing equity shareholders in their existing proportion. Such an issue is called as rights issue of shares. 2. The existing equity shareholders have preemptive rights to subscribe the new shares offered by the company. It is nothing but private placement of shares. 3. Following provisions are to be fulfilled by the company making right issue. A. Rights shares are sold to the existing shareholders at a price which is lesser than its market price. B. A letter of offer has to be sent by the company offering right shares to the existing shareholders. C. The letter of offer shall contain the following information. 1. The number of shares offered. 2. The period of offer, that is, the period of offer shall not be less than 15 days and more than 30 days from the date of offer. 3. The right to renounce, that is, the shareholders have a right to give up their shares in favor of any other person. D. This letter of offer can be sent by registered post, speed post, courier, or through electronic mode. E. If a shareholder does not respond to the rights issue within the period of the offer, the company can offer his shares to new investors. F. The company must raise minimum subscription, that is 90% of the issue. 4. Thus, company has to fulfill certain provisions while making right issue. 2. To issue bonus shares, a company has to fulfill certain provisions. Answer. 1. Bonus shares are the fully paid shares issued free of cost or as a gift to the existing equity shareholders by the company out of its accumulated or undistributed profits or reserves. 2. The reputation of the company and market value of its shares increases if a company issues bonus shares. Bonus shares enjoy the same rights as equity shares, like voting rights, receiving dividend, etc. 3. It is the process of converting undistributed profits into share capital. Hence, it is also called as capitalization of reserves or profits. 4. Following provisions are to be fulfilled by the company making bonus issue. A. Bonus shares can be issued only out of free reserves or securities premium account or capital redemption reserve account. B. Company cannot issue bonus shares out of reserves created by revaluation of assets. C. Company cannot issue bonus shares instead of dividend. D. Once the announcement of bonus shares is made by the company, it cannot be revoked or withdrawn. E. Company can issue only fully paid bonus shares. F. Shareholders cannot renounce, that is, give away their bonus shares to another person. G. Minimum subscription criteria does not apply to bonus shares. 5. Thus, to issue bonus shares, a company has to fulfill certain provisions. 3. ESOS is offered by a company to its permanent employees, directors, and officers. Answer. 1. Under Employee Stock Option Scheme, that is ESOS, permanent employees, directors, or officers of the company, or its subsidiary company, or holding company, are given the right to purchase the equity shares of the company at a future date, at a predetermined price. 2. ESOS is an employee benefit plan, which allows them to participate in the financial success and profitability of the company, for which they are working, through ownership of shares in the company. 3. It is especially useful to those companies whose business performance depends upon the knowledge, skill, and experience of its employees. For example, software companies, media and advertising companies, etc. 4. Company has to comply with the following provisions related to ESOS. A. A company may offer the shares directly to the employees or through an employee welfare trust. B. Shares are to be offered at a price lesser than their market value. C. There should be a minimum vesting period of 1 year, during which the employee can use his option to apply for shares granted to him. D. Company will specify the lock-in period during which employee cannot sell his shares. E. Till the employees buy the shares issued to them, they do not enjoy any dividend or voting rights. F. For issuing ESOS, company has to get the approval of shareholders by passing a special resolution. G. The shares issued under ESOS to an employee shall not be transferable, pledged, hypothecated, or mortgaged. H. The company has to constitute a compensation committee for administration and superintendence of the ESOS as per the provisions of SEBI, Share-Based Employee Benefits, Regulations, 2014. 5. Thus, ESOS is offered by a company to its permanent employees, directors, and officers. 4. Company has to fulfill general principles or rules for allotment of shares. Answer. 1. Allotment of shares means giving or distributing shares to share applicants or to specific persons with whom company has entered into contracts. 2. After allotment, a share applicant becomes a shareholder of the company. Thus, it gives rise to a contractual relationship between the shareholder and the company. 3. Every company issuing shares has to comply with the provisions of the Companies Act 2013 with regard to allotment of shares. These are known as statutory provisions. 4. In addition to the statutory provisions, a company has to follow following general principles or rules. A. Proper authority. Allotment must be done by proper authority. This authority can be Board of Directors of the company, or the allotment committee, set up by the board for this purpose. B. Allotment must be against application only. A company can allot shares only if it has received a written application for shares from the applicant. C. Reasonable time. As per the Companies Act 2013, allotment has to be done within 60 days of receipt of application money. Company can start making allotment from the 5th day from the date of issue of prospectus. D. Absolute and unconditional allotment. Prospectus and share application form contain the terms of allotment of shares. Shares should be allotted on the same terms. Company cannot add new conditions at the time of allotment. E. Communication. The allotment must be duly communicated to the applicant by sending a letter of allotment or allotment advice. This letter gives details of shares allotted and allotment money due. F. Allotment should not be in contravention, violation of any other law. Company has to ensure that the allotment of shares does not violate or contradict any other existing laws. For example, shares cannot be allotted to a minor. 5. A company can issue duplicate share certificate. Answer. 1. A share certificate is a registered document issued by a company evidencing that the person named in the certificate is the owner of number of shares of company as specified in the certificate. 2. In case of any dispute about membership the share certificate will be held as evidence, and not the entries in the register of members. Hence, share certificate is a prima facie evidence of title to shares. 3. A company can issue duplicate share certificate if the original share certificate has been defaced, mutilated, or torn, and is surrendered to the company. 4. A company can also issue duplicate share certificate if it has been proved by the holder that the original share certificate is lost or destroyed. 5. In case the share certificate is lost, the company issues a public notice in the newspapers and appeals the finder, if any, to return it to the company. In case no response is received within the stipulated time, then the company can issue a duplicate share certificate. 6. Duplicate share certificate should be issued only to the registered shareholders within 3 months from the date of application. It should be issued with the words duplicate share certificate stamped or printed on the face of the new share certificate. 7. If the company issues duplicate share certificate with fraudulent intention, it has to pay heavy penalty. 8. Thus, a company can issue duplicate share certificate. 6. Board of Directors have the authority to forfeit shares. Answer. 1. Forfeiture of shares means compulsory termination or cancellation of membership of a defaulting shareholder on account of non-payment of call on shares within a certain period. 2. Shares can be forfeited only for non-payment of call. Shares cannot be forfeited for any other dues from the shareholders. Thus, only partly paid up shares can be forfeited. 3. The power to forfeit shares is given to the Board of Directors, and it must be used in the best interest of the company. This is so because there are serious effects of forfeiture of shares, which are as under. A. The defaulting member ceases to be a member of the company and loses all membership rights, as his name is removed from the register of members. B. The defaulting member continues to be liable to pay the unpaid calls even after forfeiture of shares. However, his liability ceases when the company reissues the forfeited shares. C. If the company goes into liquidation within 1 year of forfeiture of shares, the defaulting member is liable to pay the calls as a past member. 4. Company has to send a notice of forfeiture to the concerned member, giving him 14 days period from the date of notice to make the payment of call, along with interest, if any. If the member defaults, even after 14 days warning notice, the board can forfeit his shares by passing a board resolution. 5. Thus, the Board of Directors of the company have the authority to forfeit shares. 7. A member of a public company can transfer shares. Answer. 1. Transfer of shares is a deliberate or voluntary act of transferring the property in shares by the member of a company in the name of some other person. 2. Every member has a right to transfer his shares. He may transfer his shares for consideration or give away as gift. The member who transfers his shares is called transferor, and the person to whom the shares are to be transferred is called transferee. 3. Shares of a public limited company are freely transferable. However, there are certain limitations on transfer of shares of private limited company. 4. A member can transfer all the shares held by him, known as total transfer, or part of the shares held by him, known as partial transfer. 5. For transfer of shares, an instrument, called instrument of transfer, should be filled in by both the parties and signed by the transferor, transferee, and a witness. It has to be submitted to the company along with share certificate and required transfer fees. 6. The application for the registration of transfer may be made either by the transferor or by the transferee. If the transfer of partly paid up shares is lodged by transferor, then the company must give notice to the transferee. Transfer of shares can take place after receiving no objection to the transfer from transferee. However, if the application for transfer of partly paid shares is made by the transferee, such a notice is not required to be given. 7. Transfer is said to be completed only when transfer is registered in the register of members. Once the shares are transferred, the liability of the transferor ends. 8. Thus, a member of a public company can transfer shares. 8. The board of directors can refuse transfer of shares. Answer. 1. Transfer of shares is a deliberate or voluntary act of transferring the property in shares by the member of a company in the name of some other person. 2. Every member has a right to transfer his shares. He may transfer his shares for consideration or give away as gift. The member who transfers his shares is called transferor, and the person to whom the shares are to be transferred is called transferee. 3. The member who is intending to transfer his shares has to fill up the instrument of transfer and submit the same, along with share certificate and required transfer fees, to the company. 4. The board of directors of the company have the authority to refuse registration of transfer of shares in following conditions. A. When the provisions given in the Articles of Association regarding transfer of shares are not fulfilled by the member. B. When the instrument of transfer is not prepared as per the provisions of the Companies Act 2013. C. When the instrument of transfer is not accompanied by the share certificate. D. When the company has a lien on the shares to be transferred. E. When transferee of partly paid shares is a minor. F. When central government gives instructions to the company not to give effect to transfer of shares. 5. Thus, the board of directors can refuse transfer of shares.